A very good afternoon to all our members. Welcome on board this wonderful day to hear this very important topic, and welcome to those that are joining us as well in this very important topic today, which is called the COVID-19 Act, where we can say either sword or shield. I beg your pardon. Either sword or shield for retailers. You know, this is where we want to bring value to our members too, because right now, as you know, the COVID-19 Act has been enacted, and there are still a lot of awareness and surety in the marketplace. And we felt that we needed to put the team together to bring some clarity, some knowledge, some understanding, and therefore we have put this program together for all our members, and of course for those that are joining us as well this afternoon. And surely we will find that towards the end of the day, when this session is over, you will find it very interesting, and hopefully our intent is that you will take some knowledge back and understanding back in this entire process for the 1 hour or so. So without any further ado, please allow me to pass to the moderator, who will take it forward, and then we will come back to you towards the end of the session. All in all, thank you once again, and I'll pass the floor to Dr. Effendi. Please take it over.
Thank you, Stan. Good afternoon, everyone. My name is Effendi. I'm from DR Group, and I've also acted on behalf of MRCA and have been asked to be the moderator for today's session. And by way of background, I think everyone is aware that we have a new act called the Temporary Measures for Reducing the Impact of Coronavirus Disease 2019, or COVID Act 2020. As we all know, the Act has been passed in the Parliament on August 25th and has been gazetted recently on the 23rd of October. So I think a lot of businesses have been affected by these measures taken by the government to curtail the impact of COVID on the public health sector. And as a result, I think this Act is supposed to help businesses to recover from the impact of these measures. And with me today, I have two distinguished panelists. The first is Datuk Ringo Low, who is the managing partner of Ringo Low and Associates. He also happens to be the MRCA legal advisor. With him, he brings more than 35 years of experience in the legal world. And on the other side, I have Mr. Michael Liu from Mary Brown Berhad. He's the business director and have been with the company for more than 13 years. So welcome, gentlemen. For the first part, I would like to invite Datuk Ringo Low to give a brief overview about this COVID Act for us, so that we can have a general baseline understanding of what this Act is about. Without further ado, please welcome Datuk Ringo.
Thank you, Dr. Effendi. Ladies and gentlemen, a very good afternoon to all of you. I hope you can hear me loud and clear. Now, this COVID-19 Act, as we all know it by this short name of COVID-19, it's been long due. Now, why I say that? Because we are into our 4th or 5th phase of the MCO. And only recently that this Act received the royal assent. Basically, it means the Agong having signed approval to it only on the 16th of October this year. So it came into effect on the 23rd of October when it was gazetted. It becomes law as of that date. Now, I would like to bring your attention to a major provision of the Act about the inability of parties to perform their contract. Now, if Ivy, can you help me to get the shared screen in respect of the provision of Section 5? Now, ladies and gentlemen, this Act, COVID-19 Act, is operational at this moment for a period of only 2 years. It can be extended if the Prime Minister agrees to it. At the moment, it will become operative until the 22nd of October 2022. Now, I'm drawing your attention to this part 2 of this act here, where it's under the caption, inability to perform contractual obligation. Now, this section 5 here, if you can see, it says that it shall only remain in operation until 31st of December 2020. Therefore, it's of limited duration. Now, how will this act help retailers in going about their business? Now, can we now turn to the next page, Ivy? Yes. I would like to invite you to look at section 7 here. Just very quickly, it says the inability of any party or parties to perform any contractual obligations arising from any of the categories, there are categories of contracts, which I shall refer to, specified in the schedule to this part, due to the measures prescribed, made or taken under the Prevention and Control of Infectious Diseases Act 1988 to control or prevent the spread of COVID-19, shall not give rise to the other party or parties exercising his or their rights under the contract. Now, what is this mumbo jumbo? It's quite long, isn't it, ladies and gentlemen? Now, you can actually cut it short. There are only 3 parts to this section, which is of relevance. The first part I want you all to take note of is the inability to perform any obligation. That means if you can't perform your obligation, that's the first part. And then the second part, it must be due to the measures prescribed. What are the measures prescribed thus far? As I can see it, it's either the MCO, EMCO, or CMCO, or RMCO. So it's tied into these measures that have been implemented by the government. And then what will happen? Then the other contracting party cannot exercise the contractual rights. I just give you an example. If you can't perform your work because of the MCO provisions, so the other party cannot exercise the right to either call off the contract or to stop paying you or to impose penalty on your inability. So this is where Section 7 comes in to help out those scenarios. Now, it doesn't apply to all contracts. It applies to 7 categories of contract. Now, let's turn the page over. We'll see the categories, Ivy. Now, the categories here, these are the express 7 categories. The first category, it relates to building works. It could be construction of a building. It could be renovation works of a house. Anything to do with builders. That's the first part of the contract. Now, the second categories of contract would be performance bonds. Performance bonds are basically bonds that contractors will have to take out to give to the employers to ensure that they will fulfill their part of the contract, failing which the employer can call on the performance bond by way of penalty in forfeiting the amount that is provided as a bond. Now, thirdly, professional services. It's very wide. It can cover accountancy, engineering, legal, and all the like. Fourth category would be lease or tenancy of non-residential immovable property. This will definitely cover the shops of retailers. Now, fifthly, those are event contracts relating to meetings, conferences, exhibitions, sports, weddings. And sixthly, you have tourism contracts. And seventhly, you have religious or pilgrimage contracts. Now, Section 5 already states here that if you want to rely on any of these contracts here to show that you are unable to perform your part of the bargain, it is only limited in duration to 31st of December 2020. Please be mindful of that because you can't go past the deadline. So therefore, if you can establish any of such contracts which will assist you to excuse your performance, the other party cannot terminate your contract. Now, if you have doubts, some of us will think, what, do I really qualify within Section 7 here? If you're not sure, my advice to you is try to invoke the mediation clause in Section 9. Can we turn the page back to page 12, Ivy? Now, look here, Section 9 provides for mediation. It says here, any dispute in respect of any inability of any party or parties to perform any contractual obligations arising from any of the categories of contracts specified in the schedule may be settled by way of mediation. Now, the Minister of Law, as through various pronouncements through the press, stated that it will only be for disputes where the value is 300,000 ringgit and below. So therefore, if you have disputes in excess of that figure, sorry, you will not be able to utilize the mediation process. Now, why I would invite you all to do the mediation process is because simply that the government has provided this avenue. And the cost, apparently the government will bear it if you are of the B40 or the M40 categories, or if you come within the definition of micro and small industries. Now, try to utilize this process to compel the mediator to get the other side to work out something, because once a mediation is successful, there will be an agreement, a settlement signed by both parties. And then this settlement will be a valid and binding agreement, and it's enforceable in a court of law. But then, of course, as mediation are always voluntary, and it might involve the consent and assent of both parties. If it is unsuccessful, I'm afraid it will just end there. So the matter may be taken to court or just dropped off. So take advantage of this if you can. At least maybe the mediator can put some pressure on the other side to be more lenient or more lax in respect of the definition of inability of the party to perform its contractual obligation. Mind you, ladies and gentlemen, if one is unable to pay the rent, you cannot rely on this inability of party to perform contractual obligation, because your inability to pay the rent is not due to the COVID measures of MCO, because you can really pay your rent from where you are, even when you can't access your premise. So that is my take. Unless, of course, you can't perform your part of the obligation, like, for instance, you are duty bound to open your shop for certain hours, certain days. Now, because the MCO, you can't do that. And then the landlord cannot penalize you, cannot take action against you, because you had to abide by the COVID measures implemented by the government. Now, moving on, those would be the provisions in respect of inability to perform contractual obligations. Now, if you have questions later on, if we do have time, I think the moderator may be able to take some questions. If not, your questions can be put into the Secretariat of MRCA. It will be considered later on by way of answers to you, either by email or maybe at the next session. Now, I would like to move to another part about Distress Act. This will be quite relevant here. Ladies and gentlemen, for those of you who are uninitiated, what do you mean by Distress Act 1951? What is this process called a warrant of distress? Now, for those of you who are familiar, please bear with me for the uninitiated. A warrant of distress is like a court order issued by the court to enforce non-payment of rentals. Now, this warrant of distress, once obtained from the court, would have the power to freeze whatever is in the demised premises or the rented premises, so that whatever items inside there cannot be taken out without the consent of the court bailiff. Now, what will happen with a warrant of distress? Once effected, there will be an auction date fixed about 2 weeks to a month later, where the things inside there will be auctioned off and the proceeds utilized to pay off the court proceedings costs, as well as to satisfy the arrears that were due and outstanding. So a lot of landlords would want to go for this warrant of distress rather than a normal legal proceeding to sue for monies owing, because to sue for monies owing, the process is much longer. It takes time, it's costlier. Distress proceedings can be obtained and successfully completed within a process of about 6 weeks to 2 months. So therefore, it's quite an attractive provision for landlords in respect of tenants who are in arrears of their rental. Now, let's look at what the COVID Act has done to assist tenants who are unable to pay their rental. Now, there are only two provisions here, Section 30 and 31. Section 30, if we look at it, it says, for the purposes of recovery of rent due and payable to the landlord by a tenant of any premises, a warrant of distress issued under subsection 5(1) of the Distress Act 1951 shall not include the distraint for the arrears of rent for the period from 18 March 2020 to 31st August 2020. Now, it looks very confusing, but basically it simply means that a landlord cannot distress for arrears of rent for this period, 18 March 2020 to 31st August 2020. That's all. But if there are arrears in January or February 2020, the landlord can apply for a warrant of distress. Or if there are rentals owing after 31st of August, let's say in September and October month, a warrant of distress could be applied for. So does it really help the tenant? If you ask me, by the time this act comes into operation, 23rd of October, it's a little too late in the day to help those who are in trouble. And let's look at the next provision under savings, Section 31. It says here, basically, I don't want to bore you with reading it long. It says that if there's any warrant of distress that was issued before 23rd of October, it's valid. So if somebody has, or some landlord has taken out a warrant of distress just before 23rd of October, even for rentals owing between the period of 18 March to 31st August, it's still valid. So this act at this stage, how is it going to help the tenant? So I'm having my reservations as well. How effective would provisions like this be? And it does not even talk about, I know there are some of you are asking about what about the unpaid, unexpired terms of the tenancy. Now, times are so bad. I don't want to continue with the tenancy if I can, but I'm stuck. I may have 12 months to go or 16 months left. Is there any way I could put an end to this? Unfortunately, no. Because the Act makes no provision for this. Our parliamentarians did not have the foresight to at least look into this angle. No, they didn't. Sadly, only two provisions here we have in respect of this distress here. So does it really help? I'm afraid it does not have enough bite. So I think looking at these two major provisions, which I have touched upon, we're about 20 minutes, into it. I can safely say that at this juncture, a lot of our retailers will not be able to enjoy the benefit of the provisions of this COVID-19 Act, which could be improved upon. Ideally, I would like to see the period extended from 31st of August 2020 to at least end of the year. If the minister can have the power to extend provisions under the Act, it can be done. The PM's department, Minister of Law, can extend all these provisions, extend the deadline, or at least push it further, because the Act itself has got a validity period of 2 years anyway, up until the 22nd of October 2022. So why not extend all this? Why just give 6 months, especially for rentals? We know that the market is still very bad now. If you don't extend it, I think a lot of people will be crying for help. So I can only suggest to each one of you retailers, air your grievances with your local MP so that they can push it up and say that, there must be more to be done in respect of the landlord and tenant situation. Now, moving on a little bit, let me see what else I can mention that might be of interest to you. Basically, for those of you who have any intention to commence legal proceedings by way of legal action against any party, you will know that your time frame to file proceedings has got a limited duration. For contracts and torts where somebody done something civil wrong to you, you want to sue somebody, you got normally a period of 6 years. But now because of this COVID-19 Act, if it so happens that your time frame of 6 years would expire anytime within the period of 18th of March, again 18th of March 2020 to 31st of August 2020, 18th of March to 31st of August 2020, it can be extended. The COVID Act says it shall be extended to 31st of December 2020. That's where if you want to commence proceedings. So the limitation period is extended. For those of you in Sabah and Sarawak, likewise, it's also extended. If you have action to be taken against the public authorities, likewise, it is also extended until 31st December 2020. So your limitation period is extended now. And then if you have debtors, people who owe you money that you want to commence legal action against them by way of bankruptcy proceedings. Now there is some amendment here. Previously, the law before the COVID-19 Act came into operation is that if you want to make somebody a bankrupt, you must make sure that that person owes you a debt in excess of 50,000 ringgit. So if the threshold of 50,000 ringgit is not met, you cannot initiate bankruptcy proceedings against the individual. Of course, there are other modes of execution if you want. You can talk to your lawyers, they will advise you. But now with the COVID-19 Act, now the threshold has also increased to 100,000. So therefore, if you have somebody who owes you money and you want to make the person a bankrupt, the debt will have to be 100,000. But then again, this is only for the duration of 18th of March to 31st of August. Okay? After 31st of August, we may go back to the 50,000. But for this duration, it's only 100,000. That's the minimum. Now, mind you, by the time this act came into operation again, 23rd of October, we already passed the 31st August deadline. So how effective is this? I don't know. You will have to be your own judge of that. And then very briefly as well, if you are having or enjoying hire purchase facilities from the banks, now you get a bit of protection here. If you are unable to pay your hire purchase installments for the duration of 1st of April 2020 to 30th of September this year. If you are in default of your installment payments for those period of 1st April to 30th September, the law under the COVID Act forbids the bank from repossessing your vehicle. Just take note of that. You have that gap of protection. But now, like I said, we are into October already. So there's no extension in sight yet. Now, so you better don't default for the next 2 months from October to November onwards. Other than that, I think basically those are the main provisions which may be of relevance to us retailers. And of course, yes, if your employees wants to complain, or if you are an employee, you want to complain to the Industrial Relations Board for unfair dismissal or wrongful dismissal, you've got your usual 60 days to make your representation to the Industrial Relations Office. And if so happen your 60 days come within the period of 18 March to 9th of June, I don't know why they choose 9th of June. It's a bit odd, 18 March to 9th of June, the period will be omitted from the calculation of 60 days. So it's suspended. So your 60 days will be extended further for the duration of 18 March to 9 June. That's in the Act. Okay, ladies and gentlemen, I think I've covered mostly of what are necessary. Of course, there are a little bit about Housing Developers Act provision regarding defects liability. I shall not go into that. I think that will bore you retailers. So that's about it I can comment on. If there are any questions later on, subject to the moderator's approval, I can come in and assist. Thank you, Dr. Effendi. Can I pass it on back to you? Thank you very much, ladies and gentlemen.
Okay, sorry, I got muted just now. Thanks, Dato Ringo, for the long and short story about the COVID Act and how it portrays time is of essence now for a lot of us, because unlike in other countries like Singapore, such act was enacted and implemented at a faster rate when the crisis was at its peak, and whereas it came a bit as you mentioned just now, a bit too late. But nevertheless, I think from our side, I think we would like to hear something a bit from the industry representative. I think we have Mr. Michael Liu on basically what actions have been taken against tenants in the interim. I think from the start of MCO until now. Maybe you could share some of the insights, what has happened in us, so that at least we can tie in together to see what are the circumstances in which the Act may help, although we know that we may need a bit of a revision here and there in order to have a bit of bite, as Dato' Ringo mentioned. Maybe Michael, could you share a bit on your side?
Hi everyone. Can you hear me? Is it
Yes.
clear? Okay. Michael from Mary Brown. I'm also the representative for this Southern Division of MRCA. We've got a number of members in the South. I just want to share a little bit of our experience. Our business, we have 160 over outlets nationwide. For airports and entertainment centers, of course, we can't open because of these traveling issues. Those are pretty straightforward. For shop lots, it's pretty easy because shop lots, we basically control our own operations, operation timing. You know, there's not much obligations and control. But the biggest issue that we face, and yesterday I did a franchisee meeting for all my franchisees, they reflect the same thing as well. Though most of the, I wouldn't say all, but most of the tenants in the malls are facing several issues. I'm not very good in legal terms, so I just hope I could just say a very layman way of explaining. Several things like for the first few months, like between March, April, and May, there's a sharp drop in sales. Of course, we're trying to sustain. Most of the retailers will try to do a break even and to survive. You know, because we're supposed to open up from May onwards. However, we extended up to today. There's still a continual extension. So I would dare say the 7 months that we are experiencing, the sales have been dropping for the first 3 to 4 months. That's pretty much given. Everyone's pretty much the same thing. We're only able to pick up our sales between, say, late May, June, and July. That is the period where we're able to earn something back to our coffers so that we can sustain, pay our salary, pay our suppliers, pay our rental. Now, most of the landlords are quite good that they speak to us. They say they'll give you a rebate. I mean, there's no 100% of course. I mean, we have to be fair to them. Some are given 30%, which the Prime Minister has been encouraged. They say that you have a tax relief of 30%, which is fair. Some are even taking one step further. There are only a handful that I know of, personally know of, that are giving 100% discounts. Basically, you don't pay for, I think, a couple of months. There are some that are giving 50%. But there are few that are a bit, I would dare say, a little bit pushy. They are actually asking us to pay out a full sum, before they are able to assist us on any rebates. I think this is quite reflective of what's happening on the ground as well. I've spoken to a lot of my members in the south, and so a lot of our MRC members in the central region, where a lot of malls are situated. My own committees itself, they have actually left a lot of the malls in the south because the landlords are unable to discuss with them. They even gave up legal letters. You know, there was a lot of dispute. There's a lot of cases going on. You know, unfortunately, they have to take a drastic action because if they continue to be in the mall, they will keep losing money and there's a lot of overhead to bear. They rather shift their investment and relocate to another place. So this bill that we are looking at, right, it does not really reflect much help, as Dato' Ringo has mentioned. We do not see much assistance at this point, except for the tax part and the bank moratorium. That is pretty much again given. But the rest of the issue that we strongly face is actually we have to keep our manpower in place. As a retailer, especially from us at SMB, we need people, we need staff. We can't run by ourselves. And to be fair, what I spoke to many brand owners, they refuse to lay off any staff. You know, a lot of big players, you know, fast food players, even our own MRC members like Makan Culture, Bo Noodles, these are the ones I do not hear any of them lay off any staff. So they're trying to hone as much as they can. But again, we are not, our cash are not limitless. No, we're not bankers. So we do need assistance in a certain way. And a lot of the members are facing issues from landlords that request for them for full payment. I also heard a lot of my members have been asked to insist to renew at this period. I myself, some of my locations have been asked to renew 6 months ahead, 12 months ahead, in 16 months ahead, 18 months ahead. It doesn't make sense for some of us retailers because we were saying we are facing COVID now. We are still dropped. I'd like to give a little bit of the perspective of what's happening on the ground. To be fair, let's say you're making 100,000 sales, right? Because of dining, you control. There's a distancing. They reduce dining in the restaurants. So we cannot do dining. We're focusing on takeaway. That makes sense. Then we have to shift our entire operation into delivery. Delivery, we eat up a lot of these commissions. So we were asking the government, can you speak to some of the delivery providers to reduce the commissions? This has been done in Singapore side. Singapore COVID bill has been said that they reduced, I think they subsidized 5%, if I'm mistaken. The government is willingly taking up 5%. If you're going to use our money, whatever money they were giving in the tax, might as well use it to the rakyat, to the citizens. We are suffering. The customers are suffering. They have to pay also additional fees. So it's actually both parties suffering. And who's winning? I'm not too sure. Maybe the government is winning. So we have to have a more direct impact for this COVID-19 bill to really assist everyone, both on the business side, also on the consumer side. So we are sort of hanging on a thread. I do see a lot of the members from outside. Unfortunately, they're closing some of the outlets. My own brand, we have closed down at least 5 to 6 stores. There's 2 in the airports and a couple of them in the malls. This is very unfortunate, but these are the drastic actions that we need to take. So other than just trying to get ourselves floating, we have to make sure that our investments are being recovered, which is impossible now. You know, so our only aim right now is to sustain whatever we can.
Michael, just to clarify, you mentioned just now some have been given letters of demand from their landlords. Apart from that, has there been any other actions beyond letter of demands or like legal proceedings? Has it happened so far?
The situation where they talk about the warrant of distress, right? I have not actually heard any of that yet, but I do know that it's happening because some of my members actually have to pay rental even they shut down the store.
Right. Okay.
So like a couple of my brands in the south, they are forced to pay the rental on a monthly basis, but because there's no sales, you know, basically like they're not making any money at all, so they'd rather shut down the whole place. Again, they were penalized for not opening. They were given penalty.
Right. Okay. Leads back to the contractual issues. I think this is the part I think we have to post back the question to Dato' Ringo. Right. Dato' Ringo, I think you've heard what Michael was saying. A lot of it are really contractual between the landlord and the tenants. And I think maybe we could ask you again whether this act, give and either party to make any material changes to the existing contracts, such as you mentioned earlier, early termination, any rent reduction. Well, if the act doesn't, so what are we left with? I mean, what can we do? Can the mediation be seen as intervention to ensure that certain practices, for example, early renewal of their tenancy ahead of time, where we're talking about 6 to 8 months. So can this be, is this a legitimate move? So maybe Dato', you could help us to enlighten us on this anomalies that we're seeing in the market now.
Okay, thank you, Dr. Effendi. Unfortunately, the COVID-19 Act falls short of the expectation of industry players like Michael Liu has just mentioned. One has to resort back to the tenancy agreement, really. It's a contractual provision between the parties as to whether, like for instance, the unexpired terms of the tenancy, how do we resolve this issue? Now, it's not been addressed by the Act, unfortunately. Even if you want to say that, oh, I can't perform my part of the contract, can I invoke Section 7? Really? Is it due to CMCO or MCO that I can't take up the rest of the tenancy to fulfill the rest of the term of tenancy? Can I invoke that provision? It's a big question mark. So it's very difficult for somebody to say that, yeah, now because of this CMCO, I can't perform my contract. I can't continue renting the premises. So therefore, I want out. Can we try that? I find it very difficult to come under Section 7 of the COVID-19 Act. But then again, I would suggest don't despair. For those of you, if it's less than 300,000, give it a shot because you've got no other choice. Either you're taken to court by the landlord or at least go for mediation in hope that the mediator can drum some compassion and sense into the landlord to give and take a little bit so that it can be by way of an agreement recorded in terms of a settlement, which will then be enforceable. Now, by the way, I would also like Ivy to flash the email address of the mediation center. Okay. Yes, if you can. Yes, ladies and gentlemen, this is the email address at the PM's department, which each and every one of you who have doubts about whether Section 7 of the COVID-19 Act can assist you, please drop them an email. Make some inquiries with that. Please take note of this email address. It'll be very helpful. Then at least you start the process of mediation sooner than having the matter litigated in court, which will be costlier. I'm sure both parties would want to try out mediation, landlord, tenants. They would want to try this out because it's free anyway for those, like I said, micro and small industries. So please take advantage of this rather than going to court. In respect of arrears, interest payment on late payments of rentals and all those, I'm afraid, ladies and gentlemen, you still have to fall back upon your tenancy agreements. You have to look there hard enough to see whether there is relief from paying interest. Look at your force majeure clause. I know each tenancy agreement of each different malls owners are different. If there is some suspension of payment of rental or interest, look hard enough, maybe you can find something there. But like I said, mostly the mall's tenancy agreement are very much in favor of the landlord. They have a whole team of lawyers to review all this much earlier on before they push it to tenants to sign it. So at this juncture, Dr. Effendi, I think we could not rely too much on the COVID-19 Act. We have to rely more on our contractual provisions. I hope that will answer and address what you have raised.
Thank you, Ringo, for that explanation. And I think that the mediation, it would also in the Section 9, it makes a point there that the parties may opt for mediation where it means that it's not obliged. It's not both parties, the landlords, for example, in this case, either the landlord or tenants are not obliged to go for mediation if they do not want to. Is that correct?
Yeah, that's correct. That's correct. It's voluntary. You can't compel the other party if they don't. So it's got to be voluntary from both sides.
Okay. So being a new act, because it was just recently passed, I think that there are a lot of confusions about how do we go about for those who would like to go through the mediation process. For example, okay, what are the steps apart from emailing pertanyaan at the Prime Minister's Department? Assuming you have gone through mediation, because I understand you are a litigation partner at the firm. So how long do we expect this process of mediation to take place? And if what are the limitations? I think you mentioned some here, but do we need to engage lawyers? I think most of us want to know, as retailers, what are the costs if it's involved, if we don't qualify under the government support. So at least we can assess all available options if we were to take this route of action.
Yeah, okay. Ladies and gentlemen, in respect of this mediation process, I would suggest that there is no real necessity to get any lawyers involved. Usually, there will be a form for you to fill up, and then you detail and particularize what are your disputes there, who are the opposing party, who are the contact persons from respective sides, and then the other party will be gotten in touch with by the mediator to see whether they will agree to the mediation process. And this process like this will probably run into maybe 2 to 3 months before the first meeting will come about. That's where both parties' view will be taken into account. Now, I think with this CMCO at this juncture, they may be resourceful enough to go do it by way of a Zoom meeting. That is possible. Just like court mediation process, we are also going through this type of Zoom meeting to get both parties to have a discussion to see whether one can resolve it or not. Don't worry about costs. I would suggest there's no need to engage a lawyer at this juncture. Save on costs. Just make sure that you can express your dispute clearly enough, identify the facts clearly, who are the opposing party, who is your contact person, and then thereafter the mediator will take it up from there. There's no necessity to engage lawyer. Don't. Cut on costs.
Right. Okay. Thanks, Dr. Ringo again. And this is this COVID Act is quite unique because it gives about amendments to about 16 other acts that you mentioned just now, among others, Limitation Acts, Sabah Ordinance, and the whole list that we have here. And I think for myself, going through the act, we will inundated with the dates that are involved in this act. As you mentioned, this act, the operation of this act, especially the inability to perform contractual obligation, can be extended. However, this is subject to the order or instruction by the Minister of Law in this case. So for the time being, we are looking, we are already going into November tomorrow. Essentially, we only have about 2 months to get everything sorted. So that doesn't give us a lot of time. So I think we would like to hear maybe from Michael, if you have any other inputs if you would like to give to Dr. Ringo from the retailer side.
I think for this part, right, I think you have pretty much covered most of the key concerns that we have from retailers' part, Dr. Effendi. I think I think I'm okay at this point, but I think the biggest concern is still on the lease agreement, because I think one of the biggest things is that when they leave, when they want to move away from the location, they're trapped by the contract. And if I'm not mistaken, some of my members have been asked to pay a full term for the 3 years leasing, which doesn't make sense, and there was no discussion to see on the middle ground. So it was quite a very difficult situation for us. This is the one I think you have mentioned a few times on contracts. I feel that the government should step it up a little bit more, step up a notch, and to say, if you were to mediate, right, we mediate in a point that we can actually benefit from it. For example, if let's say the business cannot really do well, we come up with, we can pay up, let's say 25% or 50% of whatever we owe, which is fair, to the landlord and also to us as well. I think that could be much. It makes more sense for us as investors. Otherwise, I don't think the country wants all these small and medium players to go bust and nobody is able to invest. And then there'll be a lot of jobless people on the street as well. So these are the ones that we are always concerned, see whether we can really step it up on this part.
Right. Okay. Thanks, Michael, for the input. I think I did notice just now that there's a bit of the saving provisions for the section 7 of the Act, which says that, you know, because I think one of the questions is, does letter of demand or writ of summons is considered under the section 10 of the savings of the for the inability to perform contractual obligation, Dato' Ringo. Does that mean that once you receive a letter of demand, you can no longer mediate, or you still can, or if it's a writ of summons? On the other hand, if it's a writ of summons, is it already too late then? Perhaps you will get some your opinion on this.
Yes, Dr. Fendi. Section 10 of the COVID-19 Act basically says that, whatever legal action or legal proceedings commence prior to 23rd of October, the date of coming into effect of this COVID-19 Act, will continue to remain valid, regardless of Section 7. Now, legal proceedings here would entail the filing of the writ of summons in court. A letter of demand on its own is not legal proceedings having been commenced. You cannot construe it in that way. The writ of summons must have been filed in court, and then legal proceedings would have commenced. So that's the first point. The second point is that even if legal proceedings have commenced, one can still go for mediation if both parties are agreeable. You can still try that, because don't forget, whoever filed legal proceedings are also obligated to pay lawyers money. So if they go for mediation and then they can resolve it on their own, they will save a huge chunk of lawyers' fees as well. So I would encourage those, even if legal proceedings have been commenced, and those proceedings are saved by Section 10 of the COVID-19 Act and can still proceed, but one can still try mediation. Don't give up on that.
Yeah, I have a question here from the chat room here. There's from Jay Wong that have asked, I think, I don't know whether it's she or he here, but the question goes whether the mediation can be done on a group basis rather than, because, all retailers, there are a number of retailers within a mall, but, signing this more or less on the same terms of the tenancy agreements, except for the commercial terms. Are they able to do a group action or group mediation in this case? Dato', maybe your thoughts on this.
I think it can be done. It can be done because basically at the end of the day, let's say a group of tenants from a certain mall, they group together, they sign as a group parties to the mediation proceedings. Now, if the landlord is agreeable, it will save time and cost as well. If genuinely there are some issues to be resolved, sure, it can be done. That shouldn't be any problem. Yes.
Okay, that's good to hear. I think I hope that answers the question to Jay Wong here. Another question that we have from the audience is from Kok Beng here, is with regards to the Distress Act 1951. It says that it is not applicable from 18th of March to the 31st of August. However, does this act not cover cutting off of utilities to the retail outlet for rent arrears? Apart from seizing the assets from the locations, some of the tactics used is also to cut off the electrical supplies or water supply to the units to compel the tenants to pay up. Dato', have you come across such cases, or whether this COVID Act has any bearing on such actions?
Now, the COVID Act does not grant any relief from such, I would consider, unlawful or improper acts by the landlord in cutting water or electricity supply. I think that would be a very dangerous act. If it is not permitted under the tenancy agreement, it's wrongful. It may even amount to certain offenses under certain provisions of the law. Normally, I think the more credible landlords will not resort to it. Those gung-ho types, individuals might resort to measures of this. But unfortunately, our COVID-19 Act does not address this issue at all.
Is it legal though for landlords to do so?
Usually it's illegal. Usually
Right.
you can't do that. You can't do that unless there are clear provisions in the tenancy agreement allowing the landlord to do so right from the start of the tenancy.
Okay.
Normally you can't do it. It's wrong.
Okay. Well, in terms of what if the contracts is a verbal contract? I mean, you've asked some of the members to look into our contracts between both parties, but as you know, some tenancy are on a verbal basis, which is not the best of practice, I must admit. But nevertheless, there are some cases maybe they've agreed on certain things and they did not sign on it, and then somehow they started operationing, they commissioned the retail operations at the premises, but they have not signed the agreement as of yet, because maybe the MCO was announced and they didn't have the opportunity to do so. So what happens to this sort of tenants who may not have a signed document, binding document between both parties, the landlord and the tenants? Are they bound by the contractual obligations in this case?
Now, in respect of oral contracts, now the parties will have difficulty to convince the court or the adjudicating party as to what are the applicable terms and conditions, because then you have the evidential problem. What are the usual terms and conditions affecting our oral contract? Now, could it be based on our past dealings, for instance, or what are the necessary implied terms that can be implied into our contract? Do we take it like the mall contract is quite standard? And then as such, if I've not signed here, then the mall terms and conditions are also applicable. Those are the factors the courts will take into account. What should necessarily be implied into this oral contract between this current tenant and the landlord? So past practices, standard practices, these are all that have to be taken into account. So it's a question of evidence at the end of the day.
Mm-hmm. Well, we have another question from the audience here, from Mr. Jimmy Goh here. If the cutting off of utilities or sealing of the premises is wrong, does the COVID Act similarly protect the landlord from an action by the aggrieved party? Do you get the question, Dato' Ringo?
Yeah, I got a question. Actually, one need not rely on the COVID-19 Act for protection here. If what has been done here is wrong, one can actually sue the landlord for wrongful sealing of property or premises, for whatever harm that's been done. It may even border down to criminal offense under the penal code. I would suggest that it's best that you contact a lawyer who's familiar with this, and then I'm sure they can give you the right advice by looking at the agreement and the facts that you have addressed. Civil action definitely can be taken. Criminal action may also be taken. That's my advice to you. But there's no provision in the COVID-19 Act to protect you. Nevertheless, you don't need COVID-19 Act. The normal, usual applicable laws are there to protect you.
Okay, that's good. Michael, do you have any more questions? Maybe any unanswered questions that you may have that you want to pose to Dato' Ringo?
I think Dato' covered a very good range answer, but unfortunately, Dato', very good explanation. But the COVID Act came a little too late, and there was no direct impact, as I mentioned earlier. So definitely, we need to raise more concerns. Like Dato' had mentioned, everyone has to raise to our MPs, raise to our, through the email as well, to talk to the government, make sure to have a more impactful law and acts. So at this moment, at this juncture, there's not much to comment on the COVID-19 Act because it's really useful.
So what would you suppose MRCA would do next to make repairs to the Act if possible?
Well, MRCA, we did set up a very active new F&B division head spear by our Datuk Sri Gary Chua, President Ms. Shirley. So this division, we started from, I mean, we have a lot of retailers to take care of, but because F&B is under essential list, this is the one that the COVID-19 is not actually helping us, because as essential list, there's no much dispute, there's not help on the dispute part. The government can help us. As you have said, first of all, the bill came a bit too late, and there's still ongoing requests from the landlord for us to pay. Even there's so many letter of demands that we send out, and I'm sure that the market is whole in a big mess. So the F&B division is definitely will give a bigger voice for the market in the whole country to speak to the government to say that we definitely need other interventions. For example, things like delivery platforms. A lot of our members have been complaining that because of the situation, they've been asked and been pushed to sign up with, let's say, and I cannot mention names, but the platforms, they've been charged 30% or even 35% of the commission. It's actually killing their business. So let's say the bill is 10, 15 ringgit per bill. You got to pay 30% to the person first, and it doesn't make sense. On top of that, can we use other good examples like Singapore to say the government can step in and say, I'm going to give you 6 months or 5%, I'll be absorbed for you. You guys go ahead. I'll help you to sustain it. That will keep people employed, get the staff being paid, and also the operators don't have to keep coughing out money as well. Bank loans doesn't make sense for us. Bank loans, even if you give us 2%, 3% doesn't make sense. We need revenue. There's no revenue, there's the bank interest, even if you give me 1%, it doesn't make sense. So they must have a more impactful really decisions from government to say, this bill is really here to help you. Handouts, even if you give us $600 or $800 to every citizens, right? We don't really see that in terms of business-wise and to sustain in the market as well. Because if you receive money, would you spend on your own things or you would just spend on investments? So there's a lot of queries that on these decisions that have been made. The Penjana, to be frank, it's good for citizens to pick up a lot of those cash on hands. I also heard LG, and some other brands, they are selling all the radios and televisions and laptops. So the economy is doing well because of this money given out, but again, it hits the wrong point, So I hope that we can, as a division, F&B division from MRCA, I understand that we're going to do something soon, that we're going to speak to the government, and we do have to speak. We're talking to the government every week, every other week. We led by our president. Definitely, we'll speak to them, and I urge that any of the participants in today's forum would like to know more about this division, please join us. And then we're ready to share a bit more on the division and how we can help you if you're in F&B line.
Yeah, thank you, Michael, for the good explanation on what MRCA can do. And I think that we're still on the Datuk Ringo. There seems to be a lot of interest about electricity in the tenancy contracts. It's actually from Tilaga here. Mentions that here that the electricity supply is usually a normal term in the tenancy contract with the malls. Mm-hmm. So whereby the landlord perhaps in their contract or the contract that's being referred here, the landlord has the right to disconnect electrical supply or water supply to the premises if the tenant fails to pay the bills on time or there are areas. So in this situation, what happens then, Datuk Ringo? I mean, if we talk about individual tenants on a shop lot basis, yeah, those are actionable because may not be covered by the contract. But here, if we do have a contract, what are the recourse for mall retailers?
Okay. Now, yes, like I said, if there are provisions in the tenancy agreements to allow for disruption of electricity supply or disconnection of water, then it's permissible under the contract. So if it's provided there, yes. But let me assure you, not many mall owners, or rather lawyers acting for mall owners, will advise them to do that. Because when you do that, there could be consequential loss and damage, which could flow from there, and then which may end with the landlord being taken to court as well. So I've acted for mall owners. I know there are provisions of this nature. I've advised them to be very cautious don't invoke this provision, because the repercussion can be long and far. Because if you cut electricity supply and then suddenly something happened, some things get stolen, some damage, you know, some people fall down the steps, all kinds of things, foreseeable damage can result from such action. And then you are unnecessarily dragged into a civil suit arising from there. It's not worthwhile. Yes, it can be done, but I think it will be very foolhardy to invoke such a provision, because at the end of the day, as a landlord, you have your writ of distress. You apply for a warrant of distress, easily everything is above board, done. You know, you can recover your rental. But to resort to all this, you are running a big risk. It's not advisable.
Okay.
You can do it, but not advisable. That's
Okay.
for the landlord.
That's very clear. That's very clear, Dato. I think there are good practices and there are bad practices. It depends on who's advising on the other end. I think if they got good advisors, I think they will not be doing that. I think Stan is back on the camera. I think does that mean that time is up, Stan?
No, not at all. Please,
No.
the time is. We have another few, 10 minutes or so. So please, if you have any questions, yeah.
I thought Stan is getting ready to jump into the pool behind him.
Not at all. Not at all.
Right. I think most of us, I think we started the forum today with the dialogue is to answer the question whether COVID Act is a sword or a shield. It looks like it's not a sword, definitely not a sword. It's also not really a shield. It could be like a soft toy shield. At the moment, it looks like it. It looks like a soft toy shield that doesn't really protect the retailers. But having said that, I think Dato has been quite positive in terms of giving us a bit of light and saying that we should continue with the mediation process since it's already provided in the law by this COVID Act. Apart from all that, any practical advice that you could give to our members here who may be who mostly be facing, because as you know, yesterday we were shocked by the news of Robinson's immediately closing, or going for liquidation in Singapore and Malaysia is after 160 years. And most of our businesses here do not have that long of history. So that shows the gravity of COVID-19. And I think if this situation goes unarrested, I think malls will end up being ghost malls, because businesses will no longer be able to sustain and will have to shut its doors to the public. So Dato, maybe I know legal side we've touched upon, maybe from the years of your experience, how do you see? I know this is an unprecedented crisis of a global scale. We've never seen. Nobody has a gameplay book to counter the situation. Maybe some words of advice from yourself, Dato.
Okay. Ladies and gentlemen, I mean, some of your concerns, we may have addressed it here. Some of your individual concerns may not have been brought up here. What I suggest on a productive basis is that why don't those of you who did not get the chance to air your questions or your concern or your worries about what you are going through in terms of this COVID-19 situation, maybe you can write to the Secretariat of MRCA so that we can collate all the information that we have, and then later on the Council and the President all can make constructive suggestions to the Ministry so that the necessary amendments or extensions of time be taken. Where are the shortfalls in the Act? What the Act can do for you? Maybe we should get more input from those of you viewers or participants in today's Zoom session. Please write in to MRCA so that MRCA as a united, strong voice can bring it up to the right channel and then to advance your cause and concern in hope that there could be a review or amendment of the COVID-19 Act to make it more practicable to serve all our interests. That's my advice. Thank you very much.
That's very good. That's very good advice, Dato. I think with that, we have reached gone beyond 4 o'clock. Apologies, Stan. So should I I think I can pass. There are no more questions in the, let me check the chat room. I think a lot of people want the recordings for today's event. I do not want to promise that this will be the last event. If there is a need, because at the moment, I think we have not seen how this act is being put in play. So we practically, I think, if we were to have another session, it would be after we have seen the whole process, how the mediation process has been done, for example, so we are able to advise our members better. Because currently there's a lot of assumption being made. So until as and when we get more clarification from the Prime Minister Mediation Center, I will pass the session now to Mr. Stan, who is the Secretary General. Thank you very much.
Thank you so much, Dr. Fendi. As always, Dr. Ringo, your insights, your invaluable input is so great, and thank you for spending your time this afternoon and bringing some clarity to this COVID-19 sort of seal that we have aligned for all our members and those who have joined us as well. But of course, this is not the end. As you rightly put it, MRCA is doing a lot in this area in terms of how we want to, bring this to the next level. And while this has been in work in progress, especially on the act, at the same time, we've also been engaged with some of the government agencies to see, for example, like Bandung, Malaysia, some of the areas where we have voiced up our, some of the grievances and challenges and issues and pain points that our members are facing. So we want to bring all this into different parts and parcel of the agency of the government so that we want to align and perhaps find a solution for all. But on that note, of course, I'd like to thank you, Dr. Ringo, once again. And I'd like to thank Dr. Fendi for your moderating. But last but not least, of course, Michael, thank you so much as well for bringing some of the perspectives and sharing some insights into what the industry is going through at the moment. I encourage you, before I do that, can I please have everybody turn on their screen so that we can take a group photograph? If all can put on the screen, please, so that we can take a group photograph. I will allow the secretariat to quickly take the photograph. Once you're done, can Ivy let me know the photographs are taken?
Okay. Yep, I think we have everybody. Right, Vix?
Yes. Some of them haven't opened the video.
If everybody can open the video, turn on the camera, please, so that we can take a photograph.
This is a new normal for conference photos, right?
Not only that, we won't submit this to anybody, don't worry, it's not for evidence, it's just that we would like to appreciate everybody. One way to appreciate everybody on the Zoom is to we can have a photograph, and I'm sure some is left, but that's okay. I think some of you may, some of you may writing in your questions as well, but please do that. I think the QR code was scanned earlier. And if you can take that and send in, and who knows, we might probably do part 2 of this sort of seal. Maybe we'll find another topic to, once we get more information, if there's any valuable thing that we can bring to the table, surely we will do that again. On that note, once again, on behalf of MRCA, we'd like to thank all our members for joining in today and warmly welcome those who have joined us for the first time. And we look forward to seeing you again. And on that note, take care, stay safe, and be well. Once again, have a good weekend, and thank you so much. Goodbye for now.
Everyone. Bye-bye.
Bye.